All right, we have 1 minute until our next presenter. So I will jump in and give a quick introduction in a second here. Our next speaker is Ed Millard, who will be discussing the law of the river and the futures of the Colorado River Management Program. Millard represents Montezuma County on Colorado's Southwest Roundtable and is speaking today on behalf of himself and Montezuma County. His family has been farming and ranching in southwestern Colorado since the 1880s, and over the last 2 years, Millard has devoted most of his time to Colorado River issues, the law of the river, and demand management. His research is published on an email list called Big River Issues, which the Western Water Channel often shares some of the articles on our Facebook page and our website. Millard's extended family is one of the largest water right holders in Montezuma Valley Irrigation Company in southwestern Colorado. We are delighted to hear from him today. This will be a longer presentation than we've had so far, as Ed has lots of information to impart with us, so bear with us, and hopefully, if we run out of time for questions, we will have Ed join us again at the discussion period from 11:45 to 12:15 later this morning. So with that, I'd like to hand it over to Ed.
Thanks, Max. Can you hear me?
Yes, we can.
And can you see the screen?
Indeed.
Okay, we're good to go. First off, I want to apologize. This is going to feel like a fire hose to some of you if you don't know much about the law of the river. I'm going to jump into some advanced topics. I felt 2 years ago it was important that water rights holders and the citizens of Colorado start learning about the law of the river, because it's reaching the point it's going to have some serious impacts on all of our lives, as you saw in some of the videos that Max just showed from John Stolp in particular. I'm going to go into how we got to where we are today, and I'm going to try to talk about some paths forward to hopefully make things better for all of us in the river in all 7 states in Mexico. And again, I apologize. This is going to be a lot of information, and hopefully if you don't catch some of it, I'll be glad to ask questions later or contact me offline. And you're certainly welcome to join my list if you're really interested in these issues. Thought I should start off with a quote I found in a paper by Doug Kenny and Robeson about equity in the Colorado River Compact. It says, in an arid and semi-arid region where the most precious and coveted natural resource dictates who rises and who falls, who enjoys a living livelihood and who in no uncertain terms does not. I really need to get rid of this off the side here. Okay, sorry. And who enjoys life and living livelihood and who in no uncertain terms does not. This really sums up what life is like in the Southwestern Basin. It's an arid basin. We're totally dependent on the river. And for 100 years, the 7 states in Mexico have been fighting over who gets how much out of it. The people in the lower basin, Arizona and California live in a desert, so they seem to have a keen appreciation for how important water is to it. Whereas Coloradans and Wyoming, we live in headwater states, we seem to have water everywhere, and sometimes we don't fully appreciate how important it is and how much at risk we are of losing it. And I think at this point, it's important that we all start learning how important it is and what we have to do to defend it and do as good a job as Arizona and California have been doing in defending their water. The game we're playing here is called a zero-sum game. It's a situation in which whatever is gained by one side is lost by the other because there's a finite amount of water in the river. The zero-sum games often are characterized by an economic theorem called beggar thy neighbor, where decisions based on self-interest leave the rest of the region as a whole worse off as you try to gain advantage for yourselves. The IBCC's mission is to try to prevent these beggar thy neighbor and zero-sum games in Colorado and make sure that we all work together and against one another. And we're seeking a win-win situation in which each party benefits in some way. Once again, a disclaimer, I'm a concerned West Slope water rights holder. I do speak for Montezuma County, but I am not speaking for the Southwest Roundtable of the IBCC here. They require consensus and they have diverse viewpoints on most of these issues. We're going to start in 1922 with the Colorado River Compact. I'm sure some of you have seen some of the clauses out of this compact. It was The idea of a compact was initiated by Delph Carpenter in particular after Wyoming v. California posed a threat to upper basin water rights because California had a very large number of senior water rights, and under Wyoming versus California Supreme Court decision, they could have taken much of the water out of the Colorado. The idea of the compact is to try to come up with an equitable division of the waters between the states, and then this compact would be blessed by the federal government, at which point it would become federal law. So you hear a lot about Article 3 out of the compact, but you don't often hear about Articles 1 and 2. Article 1 was pretty much the whole premise of the compact. Its major purpose was to provide for the equitable division and apportionment of the use of the waters of the Colorado River system. And again, equity is an important term here. It was designed to ensure that everyone would get an equitable share of the river. The problem was, at this point in time, as has been documented in Eric Kuhn's excellent book, Science Be Damned, the commissioners in the Colorado Compact Commission were operating under the assumption there was substantially more water in the river to be divided than there actually was, because they were in a period of flush hydrology in the teens and the 20s, which were dramatically higher than the Colorado River has run most of its history. Another important article is Article 2. The term Colorado River System, which you saw above in Article 1, means that portion of the Colorado River and its tributaries within the United States of America. As this Article 2 is written, it meant to include all the tributaries in Colorado, Wyoming, Utah, and Arizona. Article 3A is another equitable apportionment. It hereby apportioned from the Colorado system, which is the main stem and all of its tributaries, in perpetuity, to the upper and lower basins, 7.5 million acre feet each per annum. And again, they were operating under the assumption in that day that both basins would get their full 7.5 million acre foot application entitlement, which is where much of the problems are going to ensue over the next 100 years, because there wasn't that much water. Article 3D is the one that everybody hears about, because it's the one under which the upper division states are obligated, or at least to not deplete, the river flow at Lee's Ferry below Glen Canyon Dam to less than 75 million acre feet over a 10-year consecutive period. The lower basin holds us over our head at all times, and as climate change and drought increasingly threaten the river, there is some doubt at this time whether we'll be able to supply that much water in the future. But I should also point out, this is at the bottom is a quote from Delph Carpenter, again, was Colorado's compact commissioner. First and foremost, it must be ever kept in mind that the intent of the compact is to be ascertained from a consideration of the entire instrument, and that each clause must be considered in connection with other clauses. So when you read Article 3D, you still need to keep in mind that Article 2 says that the entire Colorado River system includes the tributaries, and that there is an equitable apportionment of the waters of the river. Arizona is a specialist at treating individual clauses like Article 3D in isolation and using them to pressure the upper basin for water. So it's very important we remember that all of the clauses matter and they all interrelate to each other. In 1922, Arizona's Commissioner Norville was unhappy with the inclusion of the Gila and its tributaries in the Colorado River system. The Bureau had already developed one of the first reclamation projects in the Salt River Project in the Theodore Roosevelt Dam on the Salt River. They were actively developing the water, and they could do the math. By the time that California's senior water rights were taken out of that 7.5 million entitlement, Arizona was going to be substantially shorted compared to California. So it was very important to them that the Gila River be removed and not covered underneath the compact. Unfortunately, Norville refused to propose a fix verbally or in writing to the commission in 1922. So ultimately the task fell to Commissioner Scrugham from Nevada. Nevada often plays the role of peacemaker between the other states, and this was the first instance where they did that in 1922. Scrugham came up with 4 proposals. One, they would divide the river as 7.5 million acre feet, which is the way it was originally, which was the upper basin preferred alternative. 2, there would be a race to develop 8.5 million acre feet between upper and lower, which would inevitably be won by the lower basin because they already had much more water developed. They had flat, easy to develop farmland. And once Hoover Dam was built, it was relatively easy for them to get to 8.5 million. It's much harder to develop water that quickly in the upper basin, and they knew that at the time. So there was two alternatives to this. One, the upper basin could still develop 8.5 later, and the other was the upper basin would be a loser, and they would have to try to fight for surplus water later. The fourth option is the one that apparently was actually chosen. It gave 7.5 million acre feet to both the upper basin and the lower basin. But the lower basin got another 1 million acre feet. And at a later date, there would be a conference to apportion any unapportioned water, but unfortunately, there would be no unapportioned water by the time 1963 came around, when these negotiations would ensue. Also, it said no water shall be withheld or diverted except for beneficial use. So number 4 became the basis for Article 3B, which is a constant source of controversy today, and it's an important one everybody understand. And it was also the basis for 4B on the priorities of water. The key point here is Norville, he wanted the Gila River removed from the compact, and he wanted it covered by that 1 million acre foot Article 3B exemption. But the way that California and Nevada wrote the exemption, the Gila River was not covered by that water. It basically gave the lower basin a generic 1 million acre feet of extra water, and it didn't say how it was apportioned. So the lower basin, California and Nevada sort of won, and Arizona didn't win because they didn't get the Gila River explicitly excluded from the compact. Herbert Hoover was at the time Commerce Secretary, and he was the chair of the Colorado Compact Commission. He wrote this letter right after the negotiations concluded, and he wrote to Arizona's Norville. This is just by way of registering again my feelings of admiration for the best fighter on the commission. Arizona should erect a monument to you and entitle it 1 million acre feet. And Hoover is either congratulating Norville on getting the 1 million acre feet Gila exemption, or he's teasing them that he got the 1 million acre feet for California and the lower basin, but he didn't get it for Arizona because it didn't explicitly protect the Gila. This quote came up multiple times in subsequent congressional hearings in the 40s when Arizona was trying to authorize CAP as evidence that the intent of Article 3B was in fact to remove the Gila River from the compact and give it exclusively to Arizona. But Article 3B has been a source of controversy for the entire 100 years. The California claims that it's basically a 1 million guarantee to the whole basin, that some of which can go to California. And Arizona claims that it covers the Gila. Now we're going to move on to 1928 and 29. It was 6-7 years later. The lower basin states were still fighting over how to apportion their portion of the compact entitlement, and ultimately it landed in Congress because the lower basin needed to get Hoover Dam authorized and funded so that they could create storage on the Colorado River. Without a dam on the Colorado River, it was unregulated, and it was typically huge flows during April, May, and June during spring runoff. There were runs of tens of thousands of CFS. And then during the summer, there were low flows and they ran out of water, like most unregulated waters in the rivers in the Southwest. So in 1928 and 29, they started the process of trying to authorize Boulder Canyon, which turned into Hoover Dam, and to get Lake Mead as reservoir storage to even out and regulate the river so that it was better farmland and less flooding risk. A funny thing happened. The lower basin states were still fighting over apportionment in the Gila. The Congress, as part of the Boulder Canyon Act, they put in clauses. Number 3 said, the state of Arizona shall have exclusive beneficial consumptive use of the Gila River and its tributaries. There's no mention of 3B, but a federal law basically says that the Gila was excluded as Arizona wanted. It also said the waters of the Gila and its tributaries would never be subject to any diminution whatever by allowance of water for the United States of Mexico in a treaty. So they got a free pass. These are both contrary to what the definition of the Colorado River system says in the compact. It says that all tributaries are included. So number 6 in this congressional legislation said that all provisions of the said tri-state agreement shall be subject in all particulars to the provisions of the Colorado River Compact. 3 and 4 essentially are in contradiction with number 6. And once again, this is a controversy that's run for 100 years now. The Gila River is not a small river. It's controversial. The Bureau of Reclamation estimates that the lower basin tributary flows, which include the Gila, Virgin, Muddy, Salt, are as much as 2.5 million acre feet a year. So it's not an insubstantial amount of water. The problem with the Gila is it's a wasting river. The estimated natural flow of the Gila River as it enters the Phoenix, Arizona area for that period of 1897 and 1943 was 2.28 million acre feet a year. But when it reached the Colorado River, it had wasted away due to evaporation and losses into the ground to 1 million acre feet of water. So that's why there's a discrepancy in Article 3B. It says 1 million acre feet of water, but Arizona gets as much as 2 and 2.25 million acre feet further up the river where Phoenix is. And so all indications are 3B 1 million acre feet is covering the Gila, but it's covering the point at which it entered the Colorado River, which is the 1 million acre foot river. So before we go much more with the history, I wanted to briefly cover why there's an inequity in the river today. This is a map from Audubon. It's a really excellent map. It shows you where all of the irrigated acres are in the Colorado River Basin. For example, Imperial's down here, the Salton Sea is here, Coachella, Metropolitan, Central Arizona Project is over here. Teddy Roosevelt Dam is on the Salt River here, and the Gila River is here. And one important point is there is also 800,000 acres of farmland south of the border in Mexicali. In 1922 and through the 30s, this land was being developed by a California land syndicate led by Harry Chandler, who ran the Los Angeles Times in metropolitan Los Angeles. He also developed the San Fernando Valley. So one of the controversies that will arise as we go forward is how much water does Mexico get for this farming region in Mexicali? At the time the compact was signed, it was 500 to 600,000 acres, and the Mexican treaty it would be 1.5 million acre feet. And that's one of the reasons we have a shortage on the Colorado today. The other point about this area is the Imperial Valley is very fertile soil. It was deposited by the Colorado River over decades or centuries, millennia. It's relatively flat. It's relatively easy to farm. So the Imperial Valley and Palo Verde were very easy to develop very quickly. So California won the race to develop land and file senior water rights under prior appropriation. And that was one of the reasons Delph Carpenter had to do the compact is he knew that the upper basin, it's much more difficult to develop, would lose a race to the lower basin, both in California and Arizona as far as developing farmland. This is a pie chart that I drew up that attempts to show more or less how the river was divided in the minds of the 1922 compact framers. It also has the division of the 1928-29 in the Congress between the lower basin, between California and Arizona and Nevada with a smaller slice. And this is how the upper basin's entitlement was divided between the upper basin states and the upper basin compact in the late 40s. Colorado got 3.8 million acre feet of compact entitlement at this time. We're only using 2.4 million acre feet today. In general, this is a fairly equitable distribution. There's most of half goes to the lower basin, most of half goes to the upper basin, and then there's a slice for Mexico. The one thing about this chart is it's wrong because Mexico didn't actually have a 1.5 million entitlement until 1944. They were using much less water during the time of the compact than is shown here. Now we're going to move to how the river is more or less divided today. Unfortunately, the upper basin slice has shrunk to a quarter of the river. Colorado's only using about 2.5, 2.6, and some of this is evaporation losses. All of the other upper basin states are getting less water than they were in the original allocation. The upper basin's also paying 1 million acre feet for evaporation losses on the Crisp reservoirs in Lake Powell, which are for the most part to store water for the lower basin. So we lose 1 million acre feet of entitlement in this evaporation losses here. And another noteworthy part, there's at least 5,600,000 acre feet of evaporation losses on Lake Mead, and nobody pays for them. They're really part of the structural deficit. The other important part is this big green slice here is where much of that extra water went. Arizona tributaries, the Gila, Salt, and the Verde are in this section right over here. They're around 2 million, 2.25, it varies. It's getting a little bit less as the climate warms. And the other big rivers are Little Colorado and Virgin. Arizona has exclusive use of these. Nevada gets some of this, and the Little Colorado goes to make up for some of these evaporation losses in Lake Mead and the carriage losses in the lower basin, which aren't shown on this chart at all. If you look at these before and after, that's what we thought we were getting in the compact. This quarter is what we're actually getting today. We have ceded at least 2 million acre feet of our entitlement to the lower basin, and if you count this extra million, we've ceded 3 million acre feet to the lower basin. It's not an equitable distribution. The lower basin is using far more than was the intent of the compact, and this is the reason we have a problem today. I'm going to go through why we do it and what we're going to do to work ourselves out of this problematic situation. Referencing the evaporation carriage losses in the lower basin, a finding was made by Special Master Rifkin in the Supreme Court as part of Arizona v. California on where the evaporation carriage losses would be charged. And he basically said reservoir evaporation, channel, and other losses sustained prior to the diversion of water from the mainstream are not chargeable, which means that the lower basin gets charged with no evaporation or carriage losses. And since they don't, the upper basin and the unused tributaries in the lower basin have to make up all of those losses. This is a slide that Tom Bishotsky showed at the Getchus summer conference last summer. It's for Arizona water uses by source in 2017. He only had the percentages on it, but I tried to extrapolate from that how much water they're actually using in Arizona. Depending on how ICS is charged and surpluses, they use between 2.5 and 2.8 million acre feet from the Colorado Compact and the Colorado River. They use at least 1.4 to 1.6 million acre feet from those tributaries I discussed. This is almost certainly a low number, although it's possible there may have been low flows in the Gila River that year. But you also have to count the Little Colorado. So this number could easily be 2. It's probably substantially more like 2. They use 2.8 to 3.1 million acre feet from mining aquifers and groundwater. It's a huge 40% part of their water supply. It's unsustainable. It's not being replenished, and they're basically borrowing from their future by mining this groundwater today. If you add all these up, it's quite possible that Arizona is using somewhere between 7 and 7.5 million acre feet of water out of the Colorado River system. This is as much as the entire upper basin's entitlement. It's far more than California uses. It's far more than Colorado uses. It's three times what Colorado uses out of the river. So Arizona has been very successful in developing water. They're a desert state. The Colorado is their only supply of water, whereas California and Colorado have other rivers. But you can see here who's been winning this competition for water, this precious resource in the Colorado River Basin. It's been Arizona and to some extent California. Now we're going to move to the second big controversy after Article 3B. It was a treaty to satisfy Article 3C of the compact that basically offered to provide some water to Mexico out of the Colorado River system, out of a sense of comity. It had to be supplied out of water surplus to Article 3A and 3B, if such surpluses prove insufficient, the upper basin and the lower basin each have to provide half of that deficiency. You'll notice that there is no description of an amount of water that had to be provided. They just said they would provide water by a treaty at a later date. This came to a head during World War II for a number of reasons I won't go into here, but there were two proposals. There was a proposal put forward by 6 states. It included Colorado, Arizona, Texas, Utah, Wyoming, and New Mexico. California was ardently opposed to this treaty, and Nevada was something of a flip-flopper. Sometimes they opposed, sometimes they were neutral. The important part is to understand why the 6 states above were proposing to give Mexico a 1.5 million acre feet of water. There was a memo written by Royce Tipton, who was an engineer for both CWCB and Arizona at this time, and he had proposed that they would satisfy most of the Mexico Treaty out of return flows from irrigation in Arizona, primarily, and to a lesser extent California. And they'd basically come up with a strategy that they would only have to provide 375,000 to 500,000. The number varied. Sometimes it was 600,000. The highest was 900,000 out of the main stem of the Colorado. The rest would be coming out of return flows and desilting water coming out of Arizona. At this time, Royce Tipton, this is 1944-45, Royce Tipton explicitly guaranteed the 7 states that this water would not adversely affect the use of water apportioned to the upper lower basin states in the United States by Article 3A and 3B, which I showed you at the start, and that it would be supplied out of water surplus to the 16 million acre feet. These would be words that would come back to Royce Tipton because this strategy didn't work. The first problem was there simply hasn't been that many return flows out of Arizona, especially as center pivots and submersible pumps were invented. Everybody switched to sprinklers instead of flood irrigation, so the return flows simply weren't there when the time came in the 60s. And the second problem, water coming out of Arizona that did come out of Welton Mohawk had very high salt content. It was so salty that it was bordering on poisonous. Once they started irrigating Welton Mohawk out of the Colorado River, the water table started rising, it brought up salt with it, and it was threatening all of their fields. So the Bureau of Reclamation had to put in 60 pumps. They had to pump out the salty water, and they dumped it in a canal, and they dumped it in the Colorado River. In the 1960s, when they started doing this, they elevated the salt content in the Colorado River going to Mexico to toxic levels. Mexico wouldn't stand for it, and over the course of the next 10 years, the Mexico obligation, instead of being off for return flows, was entirely out of main stem water. So this 375,000 to 500,000, 750,000 obligation turned into 1.5 million acre feet. And that is one of the reasons there is a shortfall in the Colorado River today, and the upper basin has to make up that 750,000, which is our half, every year. And this is one of the key sticking points of the problem we have today. Gene Breitenstein, he was a CWCB lawyer, he'd go on to be an appeals court judge, was a key advocate for the Mexico Treaty along with Royce Tipton and Clifford Stone from the CWCB. He was arguing that there's a risk that if we didn't give New Mexico enough water, the dispute would go to international arbitration and there would be an uncertain outcome. Mexico could get more water. They could get maybe up to 3 million acre feet. This was under the Inter-American Arbitration Treaty that was signed in 1929, right after the Lower Basin Compact was signed. And he wrote 2 papers on this subject, which if the slides are available, you can read them both on the Pan-American Arbitration Treaty and the Mexico Treaty. The problem we have now is we don't know if this would have gone to arbitration or how it came out, so we don't know if Gene Breitenstein took the wise path or he took the wrong path. California was the sole opposing street, and they called on Herbert Hoover, which is the former president and the former compact commissioner in 1922, to write an opposition letter. And he outlined a number of reasons why he thought the 6-state approach and the Mexico Treaty was wrong, and it was going to cost dearly all of the states in the Colorado Basin in the future. One of his statements, he said, without a treaty, the bogey of arbitration need not frighten us. So he's basically saying everything that Gene Breitenstein was saying was basically a bogeyman, and that we should, if we don't get a treaty that's fair, we should have just gone to arbitration and we would have won. Another comment he made, I'm sure none of the commissioners who negotiated the compact had any idea that our government would offer to guarantee Mexico any such amount as the 1.5 million acre feet stated in the proposed treaty. At the time they did the compact, Mexico was using 500,000 to 600,000 acre feet. The most they had used in the entire period was 750,000 acre feet, or half of the Mexico Treaty obligation. Hoover went on to say, the United States, that But had it been suggested that the United States was to be penalized in the future for having to furnish free to Mexico a volume of water made available by works constructed in the United States to supply land made possible development only because of those works, I know it would have met opposition with the compact framers. He wasn't sure that a compact would have been met if they had had to meet this obligation. Hoover knew the Colorado River and the compact as well as anyone. He knew the history. He was adamantly, violently opposed to giving Mexico 1.5 million acre feet in 1945. Now I'm going to jump ahead to 1968, when Congress was debating authorization of the Central Arizona Project and a series of Upper Basin compacts. One of the sticking points was that 1944 treaty. This was 24 years later. Mo Udall, who was one of the lead advocates for the Central Arizona Project in Arizona, he's a senator from Arizona, congressman from Arizona, said at the time, "It seems to be no secret that Senator Conley of Texas was the chief proponent of a new treaty with Mexico relating to these rivers, the Rio Grande and Colorado. Both were included in the treaty. Texas was, the problem with the Rio Grande is the lower Rio Grande is fed largely by tributaries coming from Mexico. Texas wanted more water in the lower Rio Grande, so Udall is accusing Senator Tom Connolly from Texas of basically giving away half of the water, 750,000 acre feet of water out of the Colorado in exchange for more water in the Rio Grande. He also is sharply critical that this is giving Mexico first call on the river for a net of 1.5 million acre feet ahead of all of the 7 states. If you go back to what Hoover said here, the key point that California made all along is Mexico could never have used 1.5 million acre feet out of the Colorado River, were it not for the fact that the Upper Basin built Hoover Dam and regulated the river. Before Hoover Dam, they could only irrigate April through June. They ran out of water the rest of the year. After Hoover Dam was built, they had a regulated river that ran year round, and they started farming in the winter, raising winter lettuce, and they had year-round irrigation, and it basically allowed all of the parties to use more water. California's argument is they did not build Hoover Dam to give water to Mexico. And that's the same thing that Mo Udall is saying in Congress 20 years later. Udall goes on to say, at the treaty hearing, numerous opposition witnesses warned that a shortage situation would ultimately come to pass, as it now seems clear will be the case. One of those was Herbert Hoover. We think that the United States, having undertaken this as a national obligation, notice national obligation is an important term, for a valid international reason, should not require the farmers, the water users, the cities of the Colorado River Basin to make good on this federal promise. A key provision in this 1968 legislation is it said the United States Department of Interior had a national obligation to augment the Colorado River from outside sources to make up for the 2.5 million acre feet, 1.5 million acre feet of which was this Mexico Treaty obligation that they thought was unfair and was causing the shortages on the Colorado River. I should probably stop at this point. If you hear about the Colorado River crisis today, you'll hear that most of it's caused by drought and climate change, which is certainly true. There's no surpluses on the river, and there haven't been for the last 20 years. But back in 1945 and in 1968, everybody working on the Colorado River knew that the river was being overallocated and that there would be shortfalls in the future if there was a drought. So this is not a new problem. It's a 50 or 100-year-old problem. The Interior Department's had this national obligation since 1968. I'm not going to go into much detail on this. This is, again, the law of the river is long and complicated. Arizona spent most of the 1940s trying to get Congress to authorize funding for the Central Arizona Project, and they failed because California was blocking it. So in the 1950s, Arizona sued in the Supreme Court. The case ran until a decision in 1963. The Arizona had previously tried to kill the compact in 31, 34, and 36 altogether in the Supreme Court and failed. California tried to join Colorado, Wyoming to the case so that they would side against Arizona, but Colorado and Wyoming refused, and they were not joined to the case. Their position at the time was that Colorado and Wyoming were trying to get crisp reservoirs built, Lake Powell and the Upper Basin crisp reservoirs, and they did not want to get embroiled in this controversy, so they sat on the sidelines. It was a decision that they would live to regret because Arizona won the case in 1963. If you want to read this case, there's a special master's finding by Rifkin in 1960, and there are two dissents, one of which is by Supreme Court Justice William Douglas, that are really worth reading if you want to understand what their thinking was. I just cherry-picked one passage from Douglas's dissent. He said, with due respect, the majority achieves that result by misreading the Colorado River Compact, the Project Act, and by misreading the legislative history leading up to the California Limitation Act. He's basically saying that the majority opinion got everything wrong. Unfortunately, this is a decision we're going to live with probably forever now, and unfortunately, many people think it was wrongly decided. Larry McDonald, he's a Colorado, Wyoming-based lawyer. He worked at the Getchell Center. He actually helped found the Getchell Center. He offered some of these opinions. Arizona v. California fostered unsustainable increases in consumption of basin water and created uncertainties in the meaning of the 1922 compact that are now at issue. Arizona's attorneys and advisors recognized their position was weak under equitable apportionment, and they developed a strategy emphasizing decisions made by Congress and the Secretary of Interior that had already determined Arizona's rights as a matter of law. He's talking about the basin in the Boulder City Projects Act, primarily in 1928 and 29, and contracts written by the Secretary of Interior to distribute water to the lower basin states. The last line is probably the most important that you should realize through this whole process. Arizona's uncompromising resistance ultimately yielded significant benefits for the state. Since this decision, none of the states have been willing to litigate again to any extent, but Arizona's willingness to litigate won them major concessions on the river, and they benefited mightily. It's probably unlikely we're ever going to litigate again, so we can't undo some of the advances that Arizona made in their compact entitlement. Larry McDonald goes on to list basically all of the points of contention that the upper basin has with the lower basin. It's some of the ones I just covered, that the Gila is part of the Colorado River system. Its water supply should be subject to the provisions of the 1922 compact, which makes a 2.2 million acre foot difference in the compact. And its uses must be considered in determining both the lower basin is consuming and deciding who bears responsibility for the Mexico Treaty obligation. He goes on to say that maybe these will be resolved by the Supreme Court, but I hope and doubt we'll ever go there. This is Royce Tipton again. 20 years later, he said that the Mexico Treaty wouldn't interfere with water for either basin, and it would be satisfied mostly out of return flows. He would live to regret these statements when he wrote a study of water supplies of the Colorado River in 1965 for the Colorado Water Conservation Board. 20 years later, he says, any increase in the use on the lower river must now be made from water apportioned to the upper basin, but now unused by it. So he's basically saying at this point that there aren't 15 million acre feet in the river, and that the upper basin is going to have to concede millions of acre feet out of its unused entitlement to balance the structural deficit in the lower basin. At present, the aggregate demand on Lake Mead is close to 9 million acre feet per year. This is without cap. It's with 1.5 million losses in overuse. It's with the Mexico Treaty. If you add in cap, there's another 1.6, so you get to a minimal need in the lower basin for 10.6 million acre feet. He's basically predicting in 1965 what the structural deficit would be. Even present uses on the lower river are dependent on significant amounts of water released from Lake Powell in excess of those required by the Colorado River Compact. And the 9 million acre foot releases we've been seeing for the last 5 or 6 years on the internet guidelines are exactly that. They have to get at least 9 million to have any chance of balancing the lower basin. This is in 1965. The Central Arizona Project is under consideration in Congress again to try to get funding. The UCRC was opposed for CAP coming online because they knew it would create a structural deficit in the lower basin and they would have to supply the water. So they got together. This is documented by Thomas Cahill in the Congressional Record in 1968 from a speech he gave in 1965. They got together and proposed amendments. And one of the key amendments says that all federal projects within the lower Colorado River Basin must be limited so as not to prejudice, impair, or preclude the future federal authorization of projects which will be required for the annual consumptive use by upper basin states of water that may be physically available after delivery of 7.5 million acre feet at least vary. These negotiations at UCRC were going on in 65 and 66. They also had to negotiate with the lower basin states because it was federal legislation. The agreement they came to in 1966 came up with a number of planks that are essential to the problem we have today. The first is the Interior Department was tasked to do a feasibility study of importing 2.5 million acre feet of water into the Colorado. At the time, that would probably be either coming from the Columbia in the Northwest, which was a dauntingly expensive project, or from rivers in Northern California, the Klamath and Eel, which would be politically difficult because California opposed it. But the Interior Department was given a task to try to find augmentation for the Colorado River in 1968 to fill the shortfall that we're seeing today. It also declared the Mexican Water Treaty as a national obligation. So again, the Interior was supposed to alleviate that national obligation off the backs of the states by augmenting the river. It specified how the dams on the river were to be operated, which is basically section 602 and 603 in the long range operating criteria that we operated under from 68 till 2007. It authorized construction of 5 water projects in Colorado, including the Dolores Project, Animas La Plata, Central Utah Project, Dallas Divide. And most controversially, it authorized building 2 dams, the Hualapai and Marble Canyon dams in Arizona, so that their revenues would produce enough money to help pay for the augmentation in Plank 1 and 2. There were an abundance of plans on how to augment the Colorado River drawn up in this period and prior periods and continue to be drawn up since. One was the Pacific Southwest Water Plan in August 1963. This was a plan to dam the Klamath River and build a pipeline all the way south to Southern California. There was a plan to build an offshore pipeline underwater, which would actually be feasible today. It would have been daunting in those days because HDPE pipe does make these kinds of pipelines possible, but it is a good 700-mile pipeline. So the costs and the pumping costs would have been extreme. And again, California was opposed to exporting any water south to Southern California. The Bureau has been doing these studies at periodic intervals ever since 2007 and 12. This was the one on the right is one that was done exclusively by Arizona recently. There were 2 problems with the augmentation plans. One is the Northwest Senate delegation and congressional delegation violently opposed it. Scooped Action is the one that made the famous quotes that they shouldn't even dream about exporting water from the Columbia to the Colorado. The thing that totally killed the plan was in 1966, David Browder of the Sierra Club started a national advertising campaign. It's quite famous. It started the environmental movement in the minds of many. Should we also flood the Sistine Chapel so tourists can get near the ceiling? And he basically managed to get a national uprising, especially in the cities, that compelled Congress and the Interior Department to cancel any plans to build Marble Canyon and Hualapai dams at both ends of the Grand Canyon. Without these 2 dams, there simply wasn't enough money to fund or build an augmentation or importation project from anywhere. So this is the first part where the environmentalists won and Floyd Dominy lost on the Colorado River. Wyoming's congressional representative in 1968, I think only had 1 or maybe 2, William Harrison, he knew exactly what was going to happen in 1968. Without the augmentation plan, there was going to be a shortfall in the river, and he called it today's problem in detail on the floor of the House. He was the sole dissenting vote. He said, Wyoming is vitally concerned the passage of this bill shall not interfere with our right to use of our water allocated to use under the terms of the Colorado River Compacts. That is exactly what happened in the future today. Water supply studies on the Colorado River indicate that there will not be sufficient water in the natural drainage area of the Colorado to permit fulfillment of all the commitments under the various compacts now in effect. Also true. There must be an importation of water into the basin if all states are to be permitted the use of waters to which they are rightfully entitled. But again, he was the sole dissenting voice in 1968. So it passed overwhelmingly. The Central Arizona Project and all the Upper Basin projects were funded, and it helped create the shortfall on the Colorado River. And finally, get to the Forgotten Law of the River, which was the original title of this presentation. The demands that the UCRC had placed on the table to pass this 1968 funding ultimately turned into Section 603 in the Colorado River Basin Project Act. And it says, rights of the upper basin to the consumptive use of water available to that basin from the Colorado River system under the Colorado River Compact shall not be reduced or prejudiced by any use of such water in the lower basin. Basically by the water going to cap, or in some estimations by half of the Mexico obligation. By translation, the lower basin and the cap can use the upper basin's unused 2 to 3 million acre-foot entitlement while it's surplus water. But when the upper basin needs the water, the lower basin cannot interfere with upper basin consumptive use or development of its compact entitlement. The question now is this happening, or has it happened, or will it happen soon? When is it triggered? These are my conjectures. I'm not a lawyer. If there's a call on based on the 2000 interim guidelines, it should be invoked. If there's an Article 3C call for half of the Mexico obligation, it probably should be invoked because Interior hasn't satisfied the national obligation. If there's a preemptive curtailment by the upper UCRC Lake Powell Powerhead to save Lake Powell Powerhead or target elevation, I think it should be invoked because it's interfering with our compact entitlement. Overuse in lower basin, exploiting the sweet spot, which Arizona's been doing the last few years to get 9 million acre feet, aquifer hoarding, crashing Lake Powell, all of which crashed Lake Powell, and potentially pushing us into a 3D call, or maybe a maybe for why this should be invoked. We certainly can't develop the rest of our 7.5 million acre feet entitlement today because the risk is too high of a compact call, so it's a maybe. We do, however, have to deliver the Article 3D obligation 7.5 million until that is litigated, if that obligation is a hard obligation. Again, I'm not asking for litigation here. I'm just pointing out this is federal law, and it is a forgotten law. I've brought this law to the attention of maybe 90 or 100 people that work in the on water issues in the whole Colorado River Basin. Absolutely, maybe 2 or 3 of them even recognized what it was or that it's there. Most of them may know that it's there, but they don't want to acknowledge its existence. Section 603 is the one part of the Colorado Compact that, well, I'm running out of time here. I'm going to have to speed this up. Section 603 is the one part of the Colorado Law of the River where the upper basin won. And it's extremely important that people know that it's there. The key point is, when the upper basin begins to use its entitlement, it was recognized in 1968 that if there wasn't sufficient water in the Colorado River, the Central Arizona Valley Project would no longer be operated satisfactorily. It's clear beyond a doubt the intent is that if there was a shortfall in the river, the Central Arizona Project is junior, and it is the one that should be shut off first. This is the augmentation study by the Department of Interior in 1975. They basically said they acknowledged that the river did need to be augmented. They should be operational by 2000, but they took no action at this time. They had other national priorities, mostly centered around energy during the OPEC embargo, so they did nothing at this point in time. The national obligation has never been fulfilled, and the augmentation's been minimal over the years. This is from Cadillac Desert. It's fairly famous. You all know it. It says the same thing, that basically firm cap water would dwindle from 1.6 million acre feet down to 300,000 in 50 years as the upper basin projects are built. And it's saying the same thing, cap is junior. I sort of hoped I'd have time to talk about the 2007 interim guidelines because they're the immediate basis of our problem. They're up for negotiation now. So we're looking at a future where we're going to have to renegotiate these and try to get a better deal. This is from a CWCB staff recommendation, January 2007. It said, compared to the lower basin, the upper basin is getting significantly less benefit, and if for any reason things do not work as anticipated, the states want to make sure the agreement operations they're under cease in full. This is why the CWCB staff said that. The blue line here is where Lake Powell elevations would be if we had stayed with the old 1968 LROC rules. The orange line is where we are today with the interim guideline rules. These 9 million acre feet releases and this large balancing release in 2011 has basically gifted the lower basin with 4.2 million acre feet more water than they would have gotten under the old rules. And as a result, Lake Powell is 4 million acre feet lower, and that's why it's perpetually on the brink of a crisis today. If we had had these 4 more million acre feet of water in Lake Powell, we wouldn't be in the dire situation we were in 2018. By contrast, here, Lake Mead is going to be 4 million acre feet lower, and the lower basin would be in a crisis and would have been in crisis years ago, 2011. If you look at releases, these are the orange dots are the releases under the old LROC. They're fairly even. There's a couple of 3 balancing releases, but they're fairly modest. This is a fairly ideal operation from an upper basin perspective. This is where they are under the interim guidelines. This is the huge balancing release in 2011. These are all of the 9 million acre feet releases that are the source of the problem today, where they've basically been draining Lake Powell to support Lake Mead at our expense. There's a really excellent paper on this. Again, I'll make these slides available. It's basically the Arizona strategy on how they negotiated to get these interim guidelines to fall in their favor. It's a how-to guide on how they did it in 2007, and everybody, as we look towards these negotiations in 2026, should read it on it to see how they did it. And Max is telling me I should probably start wrapping up and leave time for questions. So again, I'm going to make all these slides. There's a whole other half of this. It takes me 2 hours to do this presentation every time I get through it because there's so much material, but there are certainly a lot of issues to talk about in demand management and these negotiations and forest management, grand bargains, and maybe if people have questions, we can talk about some of these, or we can talk about them in the discussion later, because they're all important topics, but unfortunately they just take too much time to cover. So at this point, I'm going to stop screen sharing and pass it back to Max.
Thank you, Ed. That was fantastic. I know it was a lot of information for our viewers, and I encourage them to read those slides and contact Ed if you guys have questions post-conference. But right now, please post your questions in the chat. We'll start with one that was asked earlier in the chat while Ed was talking. Where would Mexico get its water if it didn't have access to Colorado River water? You're muted, Ed.
There we go. One answer is they would probably be doing the same thing that we're doing today, is they would probably be fallowing some of the farmland and using less water. A second alternative, in which it's really what the national obligation said, is the Bureau, the Secretary of Interior, could be putting desalinization plants at various parts of the lower basin around the Pacific Ocean and the Sea of Cortez, and start providing metropolitans municipal water supply using desalinization projects or reuse projects. And that would basically buy metropolitan Los Angeles and San Diego out of the river as far as their municipal supplies, and they would switch over to desalinization. There is a small desalinization plant in San Diego, and there was one proposed in Orange County, but they've never been built at scale. But there's a really excellent colloquium that was at the 2019 Colorado River Water Users Association in Las Vegas in December. And the San Diego Metropolitan, Southern Nevada, CAP, Upper Basin states all talked about ways to augment the river. And I actually had a bunch of slides in here, which I could probably try to show to you really quick about what some of their strategies are. But they're talking about reuse and desalinization are two of the big ones. And if they buy out the Mexico obligation, then Mexico would still get their 1.5 million acre feet, but they wouldn't take it on the backs of the upper basin states and the lower basin states. It would come out of these desalinization and reuse projects. Let me see if I can find those really quick. Okay, these are reuse projects that are currently ongoing in Metropolitan. Their initial goal is 168,000 acre feet. So if you get, 9 of these projects between reuse and desalinization, you could buy the entire Mexico obligation out of the river. They're not cheap, but they're cheap enough that metropolitan cities can afford them. The price tag on that one is 2.6 for the initial phase, and then 3.4 million for the final phase for the full project. Southern Nevada has been offering to partner with them and give them money, and in exchange for money, Metropolitan would let them have part of their Colorado River entitlement for their water supply. Since they're landlocked, they don't have access to the Pacific Ocean to desalinate. Conservation is a big strategy that the lower basin, this is Southern Nevada, their population's up 41%, water reuse has them down by 30, water use is down 38%, consumption is down by 28%, and they have goals for 229,000 acre feet of savings by 2026. And these are some of the projects that are part of Minute 323 as part of that. And then they have a bunch of aspirational projects they would like to fund and build around California and Mexico. Binational desalinization plant on the Pacific Ocean coast, another one on the New River, another one in the Sea of Cortez, recycling effluent from Mexicali Valley, and reuse of South Bay International Wastewater Treatment Plant. So there are a lot of ideas out there as to how to wean Mexico off of the Colorado River or metropolitan and resolve this structural deficit in the lower basin and take it off of our backs. And they certainly have an option to fallow, but unfortunately, the treaty obligation to Mexico is a priority one hard obligation, so they have absolutely no obligation to contribute in these shortages. They have agreed to do some under the DCP, but they have no obligation to reduce their use, unfortunately, because of the treaty. This is San Diego 20. This is again from this augmentation colloquium. I can get a link to it. It's a really good thing to look through for augmentation. This is San Diego's water portfolio in 2020. And this is in 2035. And this big purple slice here is our potable reuse project. So that's their way of winning off the river. Some desalinization. Any more questions?
Yeah, so it looks like there's a couple questions here about tribal water rights and tribal claims in the Colorado River and what that might look like in the future.
Tribal water right claims in the lower basin have been a serious problem. They still have to resolve some with the Navajo Nation in Arizona. They've mostly resolved them for the Gila River tribe, et cetera. And basically what's happened is they have gotten their compact entitlements. They don't use much of it. There's not a lot of farming in the Gila River tribe. They store a lot of it in ICS in Lake Mead, and they're basically selling the water for cash. So it's worked out pretty well for them financially. And it certainly has shorted the water supplies available elsewhere, but cities like Phoenix can generally afford to pay them for their water. So they do have a free market solution to some extent. The upper basin, Colorado has resolved all of its water rights for the most part with the Utes. I think there's no outstanding water right resolutions in New Mexico or Wyoming. The one place there's a serious problem is with the Fort Duchesne Utes in Utah. They are claiming, on paper at least, a right to maybe 700,000 acre feet out of the Green River in the Colorado River Basin. And if they were to acquire all of that, it would be fairly calamitous for the other junior water rights in the state, because if we're in a shortage now, we certainly would be worse if 700,000 were assigned to the Fort Duchesne Utes. Again, they would probably be seeking more for selling the water for cash. The Southern Utes also have water in the Animal Plata they'd like to sell for cash, but they're currently prevented from doing so. The one problem with that is pretty much the only place water on the Green River could go is they would sell it to the lower basin, and that would be selling it out of the upper basin, and there are legal problems with that. So if you've heard about the grand bargain, they've talked about a grand bargain where we would take 4.5 million acre feet out of the river and cap ourselves there, or maybe 5, and the lower basin would agree to not call us, but we couldn't do that until those water rights are resolved. Practically, I doubt they would get 700,000 acre feet because they've never really used that much water. If they were going to develop for farming, they would need substantial amounts of money to do that. If it was similar to what the Utes did, they would settle for a lesser amount of water probably, but for money to develop and use the water, or they might settle for less if they could sell it out of basin. But I really couldn't tell you how it goes. It's obviously a big issue, and it is going to have to be sorted out before we resolve all these crises on the upper and lower basin both, because there are certainly still outstanding water rights that need to be resolved. So
Great. It looks like Sam asked or mentioned that this looks like a failure by the federal government, and do you think the federal government could play a bigger role in the interstate argument going forward, or if that would even be a good idea?
All parties bear some blame for this. It's not like one party did it all. Um, the compact was a great idea, but it was flawed, especially by the fact that the lower basin states could never agree on anything. The upper basin agreed to apportion their water amongst themselves. They created the UCRC. So it was somewhat more successful than the lower basin was. California and Arizona have been in each other's throat since the beginning. And it's been very nasty and contentious. It's probably better now than it was in the early days. The Bureau and the federal government's role in this, especially if compacts are in use, is they're supposed to kind of take a back seat and help out. They're not supposed to get involved, but obviously Congress and the Supreme Court had to get involved. It certainly would have been better if the Department of Interior had stepped up and started doing some of the augmentation projects that Southern Nevada and Metropolitan are doing and relieve the entire basin from this obligation. Because the way these augmentation are happening now, they're funded by these water entities, and the water entities funding them benefit from the augmentation. It would have been better if the Department of Interior had stepped up and done that, because that was what they were directed to do in 1968. If they'd come up with 1.5 million acre feet of augmentation by now, we'd be in a much better place than we are now. But it should also be noted that there was a title change in the federal government between around 1970. Before 1970, Floyd Dominy was running the Bureau of Reclamation. Stuart Udall was the Secretary of Interior, and they were really big on building big, expensive projects. But after CAP and as the environmental movement started in 1970, and when Richard Nixon took over, there was a sea change. Floyd Dominy was fired, NEPA was passed, and environmentalism became much more prominent. And there was a big shift to not the Bureau and the Interior not wanting to build big projects. So they've shied away from doing augmentation ever since. They just haven't had the funding, congressional support, and the mandate. So one thing we don't want in the upper basin is we don't want federalization of the upper basin. We want the UCRC to manage our water, which is it's local control. It's appointed by the representatives of the states. If you saw recently, Bruce Babbitt last week, he proposed a federal irrigated CRP project as a way to retire enough land in the farmland in the upper and lower basin to retire 1 million acre feet of water and use it to fix the structural deficit. But if that were to happen, you could see a case where the federal government would be up in Colorado buying up our water rights for 10 to 30 years, basically permanently, fouling fields the same way they do for dryland CRP. If you drive around in dryland areas, you'll see fields that are basically dirt and have been for 10, 20, and 30 years. We don't want to see the federal government coming up here and buying water out of our agriculture areas to send down the river to try to balance this deficit. So it's better if we don't play the zero-sum game, that we have a win-win where we all work together and start doing these projects. Another big one that the federal government is helping out with is forest management, which I should have probably spent more time talking about some of these forward-looking things. I should briefly point out there's 2 projects that are really exciting that are going to help a little bit. One of them is industrial demand management. There's basically 162,000, maybe now 144,000 acre feet of water in the upper basin that's being used for thermal coal-fired power plants. They use 20,000, 22,000 acre feet sometimes for each of these big plants. They're all being retired because coal is not cost competitive anymore. So there's a windfall of 144,000 acre feet available. If we could retire that and put that in Lake Powell and fill our water bank in Lake Powell, it would be a 4% reduction in upper basin consumptive use. It'd be enough water for 1.5 million people in Las Vegas. The problem is we have to get funding, and right now the water won't fit in the demand management water bank because of the way the legislation was written. And the other one, which is also exciting, is forest management. It would be possible to manage our forest using thinning and clear cutting of small blocks. We could generate enough water to generate 6 million acre feet annually. This, however, probably wouldn't sit well with environmentalists. It was proposed in 1979 after drought then. And there is an excellent paper on it by Alden Hibbert in 1979. You would have to be fairly aggressive, but you could save 500,000 acre feet or 3.5% of the Colorado River Basin just by treating 22% of the forests. Our forests are too dense. They drink water just like our crops do, and as temperature rises, they're drinking more. So part of the solution here is forest demand management, and the federal government really could step in with that.
Excellent. Juan is asking, Ed, what are some of your thoughts on IDD's position in attempting to uphold the DCP due to claims that the Salton Sea is part of the Colorado River Basin?
I'm in an agricultural region, so is Imperial. We're in a fight for survival because we're kind of the target to have our acreage fallowed and turned to dust. And I empathize with Imperial. I realize there certainly is a problem in California as metropolitan use more, they have to reduce theirs, but I certainly understand where Imperial is coming from. Pat Mulroy from Southern Nevada retired, and a few others have recently proposed an idea that I thought was kind of cool. It may be expensive, but there is a proposal out there that they could basically pave the banks of the Salton Sea with gravel. And that would be a way to hold the dust down and solve Imperial Irrigation District's problem. But I tend to side with Imperial because if you've seen the dust clouds that blow through that area, it is an environmental calamity. And that's often what happens when you start demand managing water, is you create an environmental problem when you once had a water problem. So I understand it, and I think they should have been listened to more in the DCP process. But there was time constraints, and it was a hard problem, and so I'm entirely supportive of Imperial Irrigation District, although the overuse in the lower basin certainly causes problems for Lake Powell and Lake Mead. So we all need to work together to try to fix that problem. There are ways to fix it, they just cost money.
Yeah, and if anybody's interested in information on the Salton Sea, you can shoot me an email after the conference. I have some great articles that I can share with you. Are there any other questions? Oh, Zach has a question here. Do you think the doctrine of prior appropriation and the use it or lose it rule is still an applicable system for the Colorado River Basin, and are there any alternatives?
Well, as Max said when he introduced me, my family are large water rights holders in the Colorado River Basin, so I'm afraid I'm a little bit biased. You do have to realize that in the 1880s and 1890s, you risked your life to move out here to develop these areas. The only reason that the miners did it or the ranchers and farmers did it is they had to know they would have access to water. It is certainly a problem that over time uses have changed and priorities have changed, but it's also not fair to say to all of these families that have invested 100 years and 5 generations into developing these communities that they have to give up their water rights. And it's also true that we kind of need to have open spaces in Colorado. I mean, if you go to other parts of the world, people still think of Colorado as mountains and ranchers and cowboys and open space. And a lot of that is ranches and farmers that are using irrigated water. I'm not sure you want to wipe them out. And I think the other lesson we have from COVID recently, as unfortunate as it is life in crowded cities isn't always the greatest. And there are people that live out in these areas. They live out here because there is water available so that they can farm and ranch. And I don't think you want to lose that lifestyle. So again, we kind of have to get creative on these reuse projects and desalination and cloud seeding and forest management. And we need to try to get it so that the Colorado River has enough water to get by for everybody. And I don't think you want to overturn the whole system. There certainly have been talk in Australia and others about common good and basically reallocating all the waters, but I certainly would oppose that. But I can see why newer arrivals and people of cities would want to do it.
Great. Yeah, we also discussed some cloud seeding and forest management yesterday. For anybody in the chat or in the conversation, we will be posting these recordings eventually after we get them edited, so we can go back and review that as well.
Definitely go look at the colloquial at the water CRUA, because that was really great on all of these topics. The IBCC and the state of Colorado, I think they're adding a forest management plank to the Colorado Water Plan. I don't know if it's gotten out to you. I'll send it out to Max, but CWCB is having a series of 4 listening sessions on the water plan. Maybe former Commissioner Eklund will be talking about it. And I think you guys might want to at least listen to one or two of them because they're going to be talking about all these issues and the update to the water plan coming soon. And that is a chance for your voice to be heard on what you care about demand management or forest management, et cetera.
Great. Yes, we'll share that stuff on our Facebook page and hopefully our website as we get updated. We have 5 minutes left for questions for Ed. Do we have anything else that we want to speak to now? Otherwise, hopefully, Ed, you can join us for the discussion at 11:45. Hopefully, James Eklund will be able to join us for that time period as well.
You can count on it. I'm certainly getting interest in Commissioner Eklund's presentation as well.
Excellent. If there's no more questions, we might jump in the break a few minutes early because I know this was a long session. Please join back after the break for the presentation by James Eklund at 10:45. Ed, you can finish up with anything else you might want to say.
Well, I'll show you a few of these slides from the colloquium. This is Metropolitan, which is Los Angeles and San Diego. Their goal is for 1990, which was a while ago, until 2040, which is their goals. They're obviously looking for local supplies, which is reuse, desalination, and conservation to be the lion's share, and they're slowly taking themselves out of the Colorado River, which is a good thing. They're a junior water right. They don't have a stable water right. If they're going to take more water, you're going to have to wipe out Imperial and Palo Verde and Coachella. It should be noted those farming regions in California and southern Arizona are some of the most productive. That's where you get your winter lettuce and fruits and vegetables, and it would be a really sad loss if we were to lose those great farming regions in southern California. Colorado, I mean, people may say that we don't have the best agriculture, but beef is one of Colorado's biggest exports. It's certainly an industry that's under stress, and let me see if I can go back to show you where some of the water is used. Ranching is certainly an industry under stress, but it is part of Colorado's lifestyle. It's a key part of the West Slopes agriculture and economy. It would be really unfortunate if we had to lose it. So this is a slide that shows depletions from the Colorado River Basin, and it shows you that the lion's share of the water is on the West Slope. It's 1.3 million acre feet. There's 360,000 acre feet going to cities on the Front Range. There's 180,000 going to agriculture on the Arkansas and South River both, and this is where the West Slopes M&I, it's a much smaller chunk for the West Slope cities because we don't have a lot of big cities. The thing you'll see here is the lion's share of Colorado's agriculture is forage. Alfalfa is a quarter right there, forage is half, and that's basically hay and alfalfa, grass and alfalfa hay for livestock. Pasture, and again, you can see the total dominance of ranching on the Western Slope. I know many people don't like beef these days or cattle, but it is a part of Western Slope lifestyle. I mean, that's where my family came from. They were cattlemen in the 1880s. So there's a long section about demand management. Certainly, it's a topic all unto itself, and I certainly probably should pass the slides on. There's a lot of conversation about demand management going on in Colorado right now. My IBCCC is involved, and there's a bunch of work groups the CWCB has working. And I guess I should tell you that the CWCB work groups are going to be wrapping up, and they're going to be reporting to the Colorado Water Conservation Board in July, I think. And then CWCB is going to have to decide where we would go with demand management in the future. They're going to have to set a new bunch of milestones. The key problem with demand management right now is, demand management is tended to be a single payer system. The states would pay for water reduced use. And the key problem right now is all of the states are broke because of the COVID crisis. So there was a $3 billion budget deficit that they're trying to fill. So the demand management program as it was originally conceived is on hold until there's money to fund it. And it may stay on hold for a long time. The only way that it's going to be saved is if the federal government does another multi-trillion-dollar bailout to the states so that we're out of the budget hole. Otherwise, we're going to have to go to something more creative, like a true water bank where each depositor would own their own water and they would use it to protect themselves, and that eliminates the need for a single payer. So I've been pushing this recently, and it's kind of an interesting spin, different from what we've heard. but there is opposition to going to this actual water bank account. So it's an interesting question. They're going to be talked a lot about between now and September, certainly, and I can certainly make available to you links to the work groups as they wrap up, to CWCB meetings and IBCC meetings. You can follow them all on Zoom, so you're certainly welcome to come and listen to them from your homes, and that makes it a lot easier versus having to drive to them. So anyway, that pretty much wraps it up for me. Thank you so much for listening. I know it was a lot, and I'm sorry that it kind of droned on, but I hope that you're getting some feel that there's a lot that water rights holders, water users, environmental engineers need to know about what's going on in the state. Now, I hope you all get engaged, especially young people. The water buffalo in the state are getting old, and we need more young people involved. Well-educated, well-informed young people. That's what we need. Thank you so much for your time.
Thank you, Ed. For our break, we have